This is Matt LePay. Follow Luke Fickle and Wisconsin Badgers football all season long on 95.3 WBEV, the Good Karma Brands radio station.
It is 11:10. The following is a paid program. Advice and opinions expressed during this program are solely that of the Melick Law Office, not WBEV or Good Karma Brands. Right now, let's head down to the Daily Dodge TV studio and Cale Zomer.
All right. Thank you so much, Wade Bates, and welcome to Taking Care of Business, featuring today Melick Law from Rob Melick from Melick Law is joining us on the show today. If you've got a question about any estate planning things, wills, trusts, powers of attorneys, anything like that, feel free to give us a call on the program today here at 885-4446. That's 885-4446. You can also shoot us a text if that's easier for you. Maybe you're stuck at work, can't get on the phone. Shoot us a text on our text line at 887-9595. That's 920-887-9595 for the text line if you got a question for Rob Melick during the show today. And Rob, a cold one out there. Appreciate you braving the chilly temps and coming in today.
Yeah, no problem. It was definitely negative this morning, the whole car ride. So yeah, it's a chilly one.
It is. Sure. It is a chilly one. Again, that extreme cold warning out until noon tomorrow. So do please be careful out there. And Rob, we got plenty to talk about. And again, if you got questions, 885-4446 is the phone number to call in. 887-9595 is the text line if you got a question for Rob today. But want to talk a little bit. You know, usually it'd be about March or April when we'd sit down with you for your monthly visit and start talking about the warmer weather and Brewers baseball. But we want to start out talking a little bit Brewers baseball here in January because obviously some big news, some sad news for the Brewers last week with the passing of Bob Uecker. And I know if folks know you, and as we've gotten to know you on this program over the years, we know that you're a big Brewer fan like myself, and I'm sure some thoughts you have on Bob Uecker's passing.
Yeah, you know, it might be a cliche to say it, but he's the voice of my childhood. I mean, I cannot tell you how many nights, probably every night in the summer that I can recall, I went to bed listening to the Brewers game.
Yeah.
Especially if they were playing out west or whatever the case was. I mean, you'd go to bed at 9. You might wake up because, you know, old school radios didn't have shut-off features. It's not like your phone where you can have it shut off after a little bit. And, you know, there'd be multiple times, you know, ever since I was, 6, 7 years old, that was every night, listening to that Uecker game. You know, there'd be times where you could watch it on TV, but we'd choose to listen to it on the radio because Uecker was just that good and that talented. So that's definitely hard. And he was all Milwaukee. That's the other thing, too. It wasn't like he was, one of these national sportscasters who just comes to Wisconsin for, random things. He's from here. He embodies all of that. So he'll be missed for sure. So it was difficult. But, again, he was 90, had a full life, got to be doing the thing that he loved for the majority of his life, being in baseball. So it'll be tough, but it was great to have him.
Yeah, I think I don't recall if it was one of his broadcast partners or one of the former players that kind of put it in terms of I think we all knew the time was coming. 90, he was a few days away from 91, and certainly are not unlimited. But I think we were all still trying to fool ourselves into thinking he was immortal and not wanting to face that day and tough. And yeah, it's you talk about being the Milwaukee guy and being a Wisconsin guy. It was so interesting listening to some of the coverage around the state in the days following his passing, and getting to listen to some of the people that worked very closely with him, particularly in the broadcast business, and how many of them mentioned, talked about the fact that Bob could have gone anywhere. Bob could have gone up to a big network and had pretty much any broadcast gig he wanted, but he always wanted to come back here to Milwaukee, and so it's pretty neat. Any fun Uecker stories that stick out to you?
Not really. I mean, like I said, I've never met him personally. I never had that opportunity. I was up in his booth at one time. We did a tour of Miller Park. They had this really neat program. They still have it. My boys are a little too old for it now, but it's called something Sleeping Under the Stars. There's some baseball pun related to that. Night Under the Stars, whatever it is. But you get to put a tent and sleep actually on center field. And it's, like I said, I took my older son when he was probably 6, 7, somewhere in there, and he loved it. It was a great time. You got to play catch in the outfield, and part of the program included a tour of the stadium, including Uecker's press box. So I did notice there was a refrigerator about this big for those watching on TV, just full of beer. So it makes sense. It all adds up there. But that's the closest I got to directly experiencing him. But no, like I said, just the voice of a childhood. It just a lot of positive memories. Just even if I wasn't asleep, just on later nights, summer nights, listening to baseball, and because I've always been a baseball fan, and always remain a baseball fan. But it'll be different. It'll definitely be different without hearing Euchre announcing the game. So we'll see.
It was it's interesting. One of my two stories that stick out is one, when I started here, one of my first responsibilities was running the board for Milwaukee Brewer baseball games. You spent a lot of nights and weekends by yourself alone in a studio, and you kind of just had Bob there to keep you company. And I remember one game, there was so many, there's never boring to listen to. And one, for whatever reason, one of the deals that sticks out to me was probably around 2010-ish. And I was running a game, and Bob shared this story of this pack of birds at some stadium he had been playing in his playing days, and how they were wreaking havoc. Of course, knowing Mr. Baseball, it was probably just a pack of birds sitting in the outfield, but to him it was. And I'm pretty sure the story went on for about 3 innings before I kind of finally sit in the studio going, wait, what's the score of this game anyway? But you didn't even care, right? Because it was Uke, it was Mr. Baseball telling a Mr. Baseball story. It was great. And then I got a really, it's cool that you guys got that opportunity to do the camping under the night under the stars. I've seen that. Someday I want to do that. Our dog several years ago won a photo contest through the Brewers.
Sure.
And so as part of that, we got to actually get introduced on the field before a game.
Nice.
I say on the field. They don't actually let you go on the field because it's very particular. But on that, on the gravel sand walkway around you, there's all those pregame introductions. We got to be a part of that with our pup, and we had to report to the Brewers the front office when we got there for the game, and one of their interns or employees took us through the back tunnels, the inner tunnels, and so we got to see some of the batting cages and things. And so he's kind of giving us a little tour of the place, and one of the first things he showed us when we walked into the tunnels, and he goes, "Yeah, and that Escalade right there, that's Bob Euchre's, and nobody actually is supposed to park in here, but it's Euchre." And we knew exactly what they meant, because it's Euchre.
You bet.
You let Euchre park where Euchre wants to park. So certainly going to be different for baseball moving forward. We've got Rob Melick, attorney Rob Melick with Melick Law, with us here this morning for taking care of business. If you've got questions for Rob regarding estate planning, wills, trusts, power of attorneys, feel free to give us a call, 885-4446, or you can text in at 887-9595. We'll keep an eye on the text line for you as well. And Rob, one of the things I wanted to start out talking about today is power of attorneys. Because it seems like no matter how much we talk about it, I get out there and at some point I hear either misinformation or conflicting information. People get confused about what they do and what they don't do. So we want to talk a little bit about power of attorneys. And first and foremost, there's 2 different types of power of attorneys. Talk a little bit about that.
Sure, and I think your experience with misconceptions is 100% consistent with my own. The analogy I draw is this, is that you don't very often hear people talking about how there's certain information about criminal defense actions. They simply rely on the criminal defense attorney to tell them what they can and can't do, even though people generally would have more experience with that because it's on television.
Sure.
There's Law and Order shows, there's movies about that. I mean, they don't make movies about estate planning. It just doesn't happen. Nobody would watch them.
We got to get on that, Rob.
You bet. No, I don't want to bore people. Like I said, if they did a TV show about what I did for a living, it'd be canceled before the pilot got on the air. So there is something to that. But I think it's interesting to me that despite the fact that there really isn't as much common knowledge about estate planning, there are a lot of those misconceptions. And the misconceptions about powers of attorney really kind of fall into 2 groups. So the main group where they fall into, at least in my experience, is the need for having a power of attorney the moment someone turns 18. So whenever I have this topic of conversation, I start with the basic premise, and if I'm speaking in front of a large enough group, I'll always see an eye roller to it. Always happens. Every single person over the age of 18 needs to have a power of attorney. Now you may say, why on earth is that the case? Well, it's simple. But before I get into the specifics, let me just take some general statements that I think pretty much everyone would agree with about the average 18-year-old in the state of Wisconsin. Number 1, the average 18-year-old in the state of Wisconsin is a senior in high school. Okay, certainly some aren't. Some, like myself, for instance, because I have a July birthday, I graduated high school at 17, turned 18 the summer before my freshman year in college. But I think most 18-year-olds, the day they turn 18, are seniors in high school. Most 18-year-old seniors in high school still live with their parents. Not all of them. I mean, some people are emancipated minors, some people are in the military, some people move out early, whatever the case is. But again, the overwhelming majority of those folks on their 18th birthday are still living at home. Third fact, most 18-year-olds who are seniors in high school, who are still living with their parents, are usually on their parents' health insurance plan. So you have those three factors: senior in high school, living at home, on the parents' insurance plan. I think that's what kind of breeds the misconceptions about powers of attorney, because I think given those three facts, most parents of 18-year-olds would assume that if something did happen to their 18-year-old child, because all three of those facts are true, not only could the parents be able to make those medical decisions for their child if he or she becomes incapacitated, but they could certainly, at a bare minimum, receive information regarding that child's care, that child's prognosis, that child's condition. The answer is, legally, they cannot. The moment a individual turns 18, they are now subject and protected by HIPAA rights. Most people generally have heard the phrase HIPAA rights, have an idea of what that means, but let me just break it down. HIPAA is the Health Insurance Portability and Accountability Act. It determines, among other things, when and under what circumstances medical providers can share your information. Now, as a general rule, we don't want our medical information shared. We want to keep that with our physicians and nurses and things like that. But at the same time, if you ask the average 18-year-old if they were in that kind of situation where they lose capacity, would they want that shared with their parents, the answer is yes. The problem is if we have one random 18-year-old coming in due to a car accident in a coma, we don't know whether they fall into the majority of people who would want that information shared or the minority of groups that they wouldn't want that shared. So the only way to avoid that as a parent is to have your children have a power of attorney the moment they turn 18. Now, as you alluded to before, there are two types of powers of attorney. What I just described is a healthcare power of attorney.
Yep. And before we get to that, we're going to continue this conversation. Some really important information and a great look at why it's so important when you talk about having a power of attorney at 18. Why it's so important, because those are the types of situations we don't always think of. We're going to continue that conversation. First, we're going to go to the phones. We've got a caller hanging on the line. Good morning. You are on Taking Care of Business. So you got a question for Rob Melick with Melick Law.
Yes, I do.
All right, go ahead.
I have a health power of attorney. I would like to add a second person as a joint agent. Can I just write that name in and have her sign it without having to go through an attorney?
It is a good question. Here's the problem. When documents are handwritten, we don't know when and under what circumstances they were handwritten. So that's why the documents have to be witnessed. So I'm generally not a fan of handwriting those changes in. What I will tell you is this. It is very likely, though I don't know your experience, ma'am, but it is very likely that the attorney you had drafted it, if you explained to him or her what you just described to me, they will likely make those revisions at no charge, would be my guess. Alternatively, if you got it done through a facility, they would certainly be able to execute a different document, because it's important that we have those updated. Now, I do want to draw one other distinction, if I may. There is a difference between having a second agent and a joint agent. You use the word joint, ma'am, and I just want to make sure we're clarifying that, okay?
Yes.
If you have joint agents, it means they have equal authority. They both need to act. And I get it. As a father of two children, I understand why you'd want that equal. But from a lawyer's standpoint, the problem is this. Your two proposed joint agents might have very different opinions on what kind of medical treatment is necessary. If they're joint, how do you break that tie? Well,
okay,
I'm more of a fan.
Because I know they do have the same thoughts as I do.
Okay, and that's great in general. I'm just saying there might be something where it comes down to an experimental treatment, or it comes down to the administration of a particular drug versus a different drug, where they may not necessarily agree. So that's my only caution when we're talking about joint agents, is to be aware of that. The alternative is a primary and a successor. So in other words, let's just say it's child A and child B. You have child A as the primary, but child B is on there as a successor. And you have conversations with them to say, look, before a major medical decision needs to be made, child A consult with child B if time is necessary, but then make that decision. The other problem is, what if child B is on vacation at that time? and a decision needs to be made immediately. If they're joint and they each need to act, that could potentially cause a problem as well. So again,
could it be one or the other?
It could
if
be, but
they're joint.
Yes, ma'am. It could be, but what I'm saying, in my experience, I have seen banks and other financial institutions, and in this case, medical institutions, not read both as both, meaning they each need to be there, as opposed to one of them need to be there. Even if we make it explicit that, because the language I put in my documents when my clients want it to be joint is saying each with the ability to act independently.
Okay.
Sometimes they ignore that clause and say, hey, it says joint, it says both, we need both. Our lawyers say we need both. So again, it's really a question of draftsmanship. It's really a question of, again, weighing the pros and cons, weighing the fact that you want them to be joint, you value their opinions equally, but also at the same time the probability, and I can't tell you how large or small that probability is going to be, that a institution may not honor that or may require both of them to be there despite the clear language of the document.
Okay. Now here's the thing.
Yes.
You're my attorney.
Oh, well, okay.
Well, now
then,
you're in better. You're starting at a good point.
Well, then what I can tell you is this, okay? And you didn't need to share that on the air, but I appreciate that you did. I don't charge for revisions at my firm.
Oh,
so
great.
There's going to be no charge for that. So
Great. That was my other question.
yes, ma'am. Wonderful. Well, so you can just call my office at your convenience. We can schedule a time. We can talk more about whether we want it to be joint or successor,
Yes.
whatever you ultimately decide. But I can tell you, under either circumstance, there will be no charge for those revisions. You just let me know. We'll update it accordingly.
Great. Thank you so much.
You're very welcome. Take care.
Yeah. Bye.
All right, some great questions. And again, if you've got a question for attorney Rob Melick with Melick Law, feel free to give us a call, 885-4446. You can also shoot us a text at 887-9595, and we'd be glad to ask your question to Rob. And I mean, that just really goes to show as to why it's so important that we're talking about what we're talking about, because there are so many little details, I wouldn't have thought about joint versus secondary, and it really, you don't maybe think about when you're doing these things how different institutions might interpret things, and that language is so important.
It is. And again, just for the benefit of the listening audience here, let me just throw out my phone number and my address information now. So again, my phone number for any calls, any inquiries, call or text for any of my office locations is exactly the same, 262-347-3444. Again, 262-347-3444. I would imagine for most people in the listening or viewing audience, my Beaver Dam location would be the most convenient. The hires graciously let me use their office there for my Beaver Dam appointments. But I do also have a brand new office building in Saukville. Well, it's brand new to me. The building's not new, but it's new to me in Saukville. If you guys would like to drive out to my main office, meet my paralegals. I do also have locations in West Bend and Germantown. So depending on location there, I also always offer free initial consultations. So anytime you have any questions or inquiries, you want me to review existing documents, you're starting from scratch, it's always a free initial consultation. And also, if you did hear about my services from WBEV or dailydodge.com, I do afford those clients a 20% discount off of legal services. We offer night, weekend, holiday appointments, whatever works for you. Again, in my experience, the issue, what I found constantly over time, is oftentimes it is difficult. It is a challenging situation to get people to actually make that initial appointment. So I want to make it as easy as possible by doing it anywhere, offering as many times available, not charging for it. It can even be done virtually. I do offer Zoom calls. I do offer in-house visits. So any way it's possible to get that initial consultation is what I'm willing to do. So long as you live in Wisconsin. I can't help you if you're outside Wisconsin. Yeah.
Maybe you don't call from Louisiana.
You bet. Well, it's one of those things where it's like, okay, Waukegan is closer to Milwaukee or wherever than Superior is.
Sure.
But I can help the people in Superior. I can't help the folks in Waukegan based purely on the fact that attorneys are licensed by state. So I do want to mention that number again, 262-347-3444. But you're right. And again, what I always tell my clients is this, you kind of saw it live, how I handled the caller. They are your documents. And a lot of people think, well, you're an attorney, this, that. You're my boss. You tell me how you want it. My job is to make sure, one, it's legal, and two, that you understand the consequences of doing something or not doing something. At the end of the day, they're your documents, just like their attorney. That's what it's referred to. I try to simplify for my clients and call it the everything but healthcare power of attorney, right? Because there's a lot of things that a financial power of attorney does or allows your agent to be able to do on your behalf that in a vacuum you would not consider to be financial. But the idea is we want everything covered. So if healthcare covers healthcare, then we want the everything but healthcare power of attorney to cover everything else. So there are a couple differences in those documents, okay? The first difference would be, again, going back to the idea of the 18-year-old. Some people may say, okay, Rob, I hear you about the medical decisions. I hear you about how it's important for parents to be able to make those medical decisions for a newly minted 18-year-old. But they don't need a financial power of attorney. They don't have anything. You know, they have their earnings from their summer jobs, and that's it. Well, again, it goes back to the everything but the financial power, or everything but the healthcare power of attorney. If that child is enrolled in college without a financial power of attorney, you won't be able to consult with the college, make arrangements for rooms, maybe even deal with an insurance company. All of those things, an employer, whatever the case is. So that's why I recommend that package of documents for everybody who reaches the age of 18. Now, we're going to talk about wills and trusts later on in the show. Your average 18-year-old does not need a will or a trust, but every single 18-year-old needs to have those powers of attorney in place. So I talked earlier about groups of misconceptions. So that's group one of the misconception. For the young adult is what I'll refer to it. Parents thinking they have that authority and they don't. The second group that I find there's a lot of misconceptions for is the married couple. Okay.
Yeah.
And it comes on both the healthcare and the financial side. I'll give you the healthcare one first. And I've talked about this a lot. I use this kind of as a proxy. If you polled 100 random married individuals at Walmart, Menard, it doesn't matter. Pick a store, pick a place, okay? And you ask them this question. If your spouse was in a horrible car accident, in a coma, unable to make their decisions, do you think as the healthy spouse, you would be able to make decisions for them, receive information about their care, receive information about their prognosis? In my estimation, I'd say about 90 to 95 would say, of course.
Yep.
I'm the spouse. Why couldn't I? And they'd be wrong.
Yeah, I've met so many married people that just assume that,
Right.
We're married. I'm now making those decisions. Just something
Right.
happens to my spouse, but it's not quite that simple.
It's
and
not.
straightforward.
It needs to be in a document. And when I break it down the way I'm going to now, I think a lot of people make more sense. All right, let's talk facts. A little over 50%, 52% of marriages end in divorce, okay? And without getting into the anatomy of what marriages end, I would say this. Certainly a decent amount of those marriages don't end in one instant, right?
Yeah.
They end because of the progression of issues over time. Well, if you're in the middle of those progression of issues in the middle of time, you may not want your spouse making those medical decisions for you. You may want to rely on a sibling to do that or an adult child or whomever else. So we can't just assume that is the case. Furthermore, even if a marriage does not have the prospect of divorce, there's a lot of people who are married for reasons other than they love their spouse. They do so for religious reasons. They don't want to get divorced. Maybe it's financial reasons. Maybe it's for the kids. Any number of variables that come into play where, again, that particular person would not want their spouse to be able to make those decisions nor receive that information. And again, going back to the issue, when a random married person comes into an emergency room, unable to communicate, unable to receive information, we don't know which group they fall into. So HIPAA says that information cannot be shared. Now, to be crystal clear, I am only referring to incapacity. Whether it's the 18-year-old or the married individual, if they, let's say, break their leg, sure, they're in pain, but they're lucid. They can say, call my mom, call my dad, call my spouse. That's not all the accidents that occur. Sometimes people do get in those accidents where they lose capacity. If they don't have the ability to communicate, that's where we have problems. So that's the issue with the married couple for the healthcare power of attorney. The issue for the financial power of attorney kind of ties in similarly. Most married people in Wisconsin have heard the phrase, Wisconsin is a marital property state. What does that mean? Okay. Well, we could do a whole show on what that means, but I can tell you what it doesn't mean. It does not mean that your spouse has the ability to make decisions over individually held assets, okay? Let me break that down a little bit. Most married couples own assets jointly. For instance, most married couples, if they own real estate, it's typically in both spouses' names. Most married couples have joint checking, joint savings, joint CDs. That's great. One spouse becomes incapacitated, the other one's a joint owner. No problem. They can manage the money, do whatever they need to do. The problem is that most married couples also have some individual assets because the nature of these assets are such that they can't be jointly owned. I'll give you some common examples. Traditional IRAs, Roth IRAs, 401ks, 403bs, life insurance. Those assets cannot be individually owned. It's not possible. I'm sorry, cannot be jointly owned. It's not possible. So some people say, okay, Rob, that makes sense, but my spouse is a beneficiary. If I die, my wife gets my 401k. And my response to that is, that's true, but we're not talking about death right now.
Right.
We're talking about incapacity.
Yeah. What if, somebody, your spouse is in a terrible accident, it was pretty bad, they're alive, but they're going to need 24/7 care
Right.
For the rest of their life. And you go, okay, well, and they're going to be incapacitated for an extended period of time, maybe the remainder of their life. And they've got, maybe a 401k sitting there that those funds can be used, but there's got to be that connection to be able to use those.
And that's where we need the financial power of attorney. So again, it ties back to another misconception because everyone needs to do this. Now, my final point on powers of attorney is this, and it's an interesting comparison to the next thing we're going to talk about. The need for powers of attorney, okay, is not guaranteed. In other, especially for the 18-year-old. The overwhelming majority of 18-year-olds are not going to have that incapacitating event, which is a good thing. We don't want 18-year-olds to become incapacitated. But here's the catch. I don't know what the actual percentage is, but I know it's not zero.
Yeah.
I know it is somewhere north of zero. So again, why not have that plan in place in the off chance that you need to be able to make those decisions? Same thing with the incapacitated spouses. Now that goes up over time. Obviously, the longer any given person lives, the greater the probability they're going to have an incapacitating event. So we can deal with that. Have those powers of attorney in place just in case that event occurs. Because again, we're talking about powers of attorney, an event that may never occur. Someone could die in their sleep, never lose capacity, in which case the power of attorney never gets implemented. Those are the pre-death documents. Now, going back to the opposite end of the spectrum, we have death. 100% mortality rate among the human race.
Yep.
I don't see that changing in the foreseeable future. I don't know. Maybe it will.
You never know. Who knows
right.
what's behind
And
the
then
scenes,
there's a whole
right
other
now.
cast of ethical issues. Would you take the immortality pill? That's a discussion for another time. But my point is that from a estate planning standpoint, as opposed to incapacity, which may happen, death will happen. 100% chance you're going to need some form of estate planning to deal with your eventual mortality. And that's where we really get into the discussion of wills versus trust. But before I start that, if I may, let me give out my information again, just to make sure people have that. Because I've been told from many people, I see a lot of people in the community like, I see your show. You never give your information out enough. So I'm going to make sure I do that.
Yes, let's give it out.
You bet. So my phone number to reach me at any of my 4 offices, call or text 262-347-3444. Again, 262-347-3444. I do have office locations in Beaver Dam, Saukville, West Bend, and Germantown. Offer free initial consultations at any of those offices. Also, home calls or Zoom, phone call, anything like that. Finally, 20% discount for WBEV listeners and DailyDodge.com viewers. So that's what we offer. Again, 262-347-3444. Melick, M-E-L-I-C-K, Law. That's the name of my firm. 262-347-3444. But again, tying back to that point now, we're going to talk about the difference between wills and trusts, because that is by far the question that I get asked most in my practice. What is the difference between the two? So I've had this discussion with clients literally thousands of times in my career. What I have found, because I take internal notes, I look at people, how they observe and how they comprehend the information. Do I see eyes glazing over? Do I see people getting confused? I think the cleanest way for me to do it is exactly how I would do it if you were sitting in my office. I start with what a will is and what it does. And maybe more importantly, at the end of the day, what a will does not do.
Does not do.
Right.
Yep.
Because most people are with me when I explain what a will is and what it does. I tend to lose people unless I give an additional explanation when I get into what a will does not do. So let's start with the will. A well-drafted will is always going to do 2 things, and when applicable, it's going to do a third. First thing the well-drafted will does is determine who are your beneficiaries. Who or what, in the case of charities, are going to receive the proceeds of your estate after you pass away. Second thing the well-drafted will is going to determine who's in charge. I'm sure most people have heard the term executor before. That person's job responsibility is to shepherd all the assets into the estate, pay out final expenses, and then distribute the proceeds in accordance with your wishes. The third thing that the well-drafted will does when applicable, and this is yet another source of misconception and misinformation, is it allows you to determine guardianship of minor children. a will or a trust is the only way to determine guardianship of a minor child. Literally nothing else works. I have dozens of people who I meet socially or come up to me when I'm doing presentations and say, well, I have a notarized letter saying that my sister gets my kids upon death. My response to that is, great, completely unenforceable, useless, not worth the paper it's written on. If you don't have it in either a will or a trust, a court is going to allow people to petition the court, and the court is going to ultimately create an award of guardianship for the people or the person who the court believes would be in the best interest of the child to raise the child or the children, divesting their parents of that ability to make that decision. So again, if you're in that situation of having minor children, I'd argue the most important thing an estate plan can do is enable you to provide guardianship for your minor children, because at the end of the day, what are you doing? You are determining who is going to raise your children who now have lost both of their parents while at least under the age of 18. That's a pretty important decision, and an estate plan is the only way to make that decision.
On kind of a similar topic, you talk about the minor children being addressed and whose hands they're going to end up in after your death. Can a will also address if you're somebody with an adult child with that you're a guardian for, that you have a guardianship? Is that something that can address that, or is that kind of a whole different process in itself?
That's a whole different process. So what happens is once someone reaches the age of 18, let's say someone has Down syndrome, they're over the age of 18. The guardians would have to go to court and get a guardianship order. Now, typically in the guardianship order, there will be alternate guardians. So if I have a child who's 19 and has Down syndrome, they need a guardian the rest of their lives, I'd go to court, I'd have an order having me or my wife and I be guardians, and then maybe we'd nominate a sibling after the fact or someone else to serve as guardian. That is not something we could do through a will. That is a whole separate court-appointed hearing, because again, and the reason for that is relatively straightforward. A child under or 18 or under, is deemed by law to be incapacitated. So it's one of those situations where they can't sign a contract. Yep. They can't do all this. If you're 17 years and 364 days, you can't buy a car, but the next day you can. Yep. But they got to draw a line somewhere. So they're presumed to be incapacitated from a legal standpoint. On the other hand, someone who's over the age of 18 has to be adjudicated incapacitated. So you need to have a court appoint someone. Typically, it's a phrase, guardian ad litem. Guardian ad litem would meet the person, come to their conclusion, provide testimony for the judge to say, yep, I met with John Doe. John Doe clearly doesn't have capacity. We think an award of guardianship to John Doe's parents is an appropriate thing. So that's a court order. So that's a very good question, very common issue. But no, guardianship cannot be addressed through a will for a non-minor child.
Okay, very good. And I forget where we were at in the wills. We talked about what they were. Mm-hmm. Let's talk a little bit about what they aren't.
Right. So just to quickly summarize, what a will does: who gets the money, who's in charge of the money, who gets the minor kids if we have any. What a will does not do, and this is probably the most important thing I'm going to say because it really kind of directs you down one of two paths. A well-drafted will, even a perfectly drafted will, is not guaranteed to avoid probate. And that is one of the common misconceptions that I run into. I have so many people who come to me thinking, well, I want a will because that's going to avoid probate. And to be crystal clear, a will can avoid probate, but it's not guaranteed to avoid probate.
Okay.
Let's break that down a little bit. What is probate? Because again, probate is a term that I'm sure many, many people in the listening audience have heard before. Okay. Probate is the process where a court oversees the administration of an estate. When an estate goes to probate, there are a series of hearings, a series of filings, a series of deadlines, a series of events that occur before assets go from the name of the deceased to the name of the intended beneficiaries. I'll be blunt. My goal as an estate planning attorney is to encourage my clients to create plans that are guaranteed to avoid probate. Not possible, not highly likely, but guaranteed. Why? Why is probate avoidance so important? 3 reasons. First is cost. Average cost of probate in a state right now in the state of Wisconsin ranges between $8,000 to $12,000. Second is timing. Average length of probate in the state of Wisconsin ranges between 12 to 18 months. Third reason is publicity. When an estate goes to probate, the will becomes public record. Not only does the will become public record, but the amount and the character of the assets also become public record. So those are all negatives. No one wants to spend any more money than they need to, or have to wait as long as they need to, or have it be public as long as they need to. But I will tell you this. Under Wisconsin law, there are only 2 ways to avoid probate. The first way is this. And for purposes of this discussion, I'm going to assume either a non-married individual or the second of a married couple. Okay? That's the person I'm referring to. I'm not talking about the first spouse, because generally speaking, when spouse one passes away, probate is not typically implicated. It can be, but generally 95% of the time, 98% of the time, it's not. So that's what I'm referring to, non-married individual or second of a married couple. If we fast forward to the date that person passes away, and they have less than $50,000 worth of probate assets, that's considered a small estate. Small estates avoid probate no matter what under Wisconsin law. So the opposite of that statement is also true. If we fast forward to the day someone passes away and they have more than $50,000 worth of probate assets, and they only have a will, the estate will go to probate. Now, the problem is that we don't know whether an asset has become a probate asset or not until the day somebody passes away. I'll give you an example. We talk about beneficiaries, all right? So I'm going to give you a hypothetical here. My wife and I have a joint checking account, okay? Let's just say we had created a will-based plan and we had listed our two sons, Grady and Hudson, as beneficiaries on that account. Can I guarantee that that account will avoid probate? The answer is no. Why is the answer no? And I know this is a tough one from an emotional standpoint, but it's 100% true. I have no idea whether either or both of my sons are going to survive me.
Yeah.
I just don't know.
Yep.
I hope they do. I want them to, but I have no idea.
Right.
And the problem is I'm not going to know the answer to that question until the day the second of my wife and I passes away.
Yeah.
We don't know. A trust, on the other hand, has a 100% chance of surviving me because the trust can't die. So that's how I really boil it down for my clients. The trust creates the guarantee because we don't know who's going to pass away when. We know we're all going to pass away, again, until we get that immortality pill. We know that's going to happen. But we don't know the order of death and dying among us, ourselves, and our immediate family members or anybody else who would want to be a beneficiary. The trust, on the other hand, makes that not matter because the trust will never die. And that's kind of the overarching logic of trust-based estate planning. We are creating an entity that by definition we know will not pass away, and that's how we know we can guarantee we avoid probate. Now, the type of trust I recommend is what's called a revocable living trust. Key aspects of revocability: one, the creators of the trust have the ability to make whatever changes they want at any time. I call it the 3 Ds and a B: death, divorce, disability, birth. Those are 4 very common life events that will, in some cases, cause people to want to update their estate planning documents. And because the trust is revocable, you possess the ability to make those changes. In fact, if that life event occurs after spouse 1 but before spouse 2 passes away, spouse 2 himself or herself can make these changes as time goes on. The revocable living trust only becomes irrevocable, unchangeable, after the second spouse passes away. The second, and I'd argue more important aspect of revocability is that the creators of the revocable trust have full use, full access, full control over trust-based assets. We go back to that theme of misconceptions. One of the biggest misconceptions I hear there is, well, if I create a trust, I can't use the assets. I'm not in control. I have to ask my trustee for permission. And yes, there are some trusts that place those restrictions, but a revocable living trust is not one of them. With a revocable living trust, your ability to do whatever you want with whatever you have is exactly the same before you create it as it is after you create it. So again, for most people, the trust-based estate plan is going to make sense because it guarantees probate avoidance as opposed to minimizing the likelihood of it.
Got just a few minutes left here with attorney Rob Melick with Melick Law, talking all things estate planning. Feel free to give us a call, 885-4446, or you can shoot us a text on the text line at 887-9595. Rob, when it comes to the trust, is there situations where a trust isn't necessarily needed, or is it pretty highly recommended for most situations because of that whole guarantee thing?
Yeah, well, again, for most people who have relatively modest assets that we can list beneficiaries on, we can increase the likelihood that they'll avoid probate, right? But we're never going to guarantee it unless we have a trust, is the simplest way I would put it. So given the type of assets some people have, given other family circumstances, or again, just from a cost standpoint, I mean, wills are going to be more cost effective than trusts because they don't do as much as a trust does. The analogy I draw there is bicycles cost a lot less than cars, but most people have cars to get them around, particularly when it's -3 degrees outside,
exactly.
Right? There's nothing wrong with buying a bike. There's nothing wrong with using a bike. And some people who live in big cities, a bike is more efficient. But when you're living out here, typically you want the car. It's the same logic there. So if the bike is the right purchase for you, then the will is the right purchase for you, and that's what we'll do. If I need to explain explain the differences between a bike and a car for your circumstances, I'm happy to do that as well. And again, a lot of young couples starting out, guardianship's the most important thing. Maybe they're on more of a budget. Well, what I do at my firm is if you create the will with me in time one and you decide down the road to create the trust, the cost you paid for the will is offset from the cost of the trust. So you basically get a built-in credit toward the cost of a trust down the road. And I have dozens of young clients, mostly young clients, some older clients, but mostly younger clients who take advantage of that.
Speaking of kind of younger clients, one of the things I hear a lot from people, my age or, are younger, is, well, I have, after getting the chance to obviously have worked with you for a while here and being on the air with you and having been through some situations myself of some unexpected deaths in the family. And I'm a pretty big proponent of making sure, your end of life planning is in place right at 18, as crazy as that sounds. And one of the things I hear often from young people, especially these days, is, well, I don't really own much. I don't have kids, so I don't need a will. Is that the case in some cases, and why is that maybe a misconception?
Well, I think that the issue of needing a will versus needing a estate plan are two different things. In other words, if they don't have many assets, they don't have kids, again, you can make an argument that they don't need to have a will. The argument you can't avoid, though, is that person has a possibility of becoming incapacitated. Those folks do need powers of attorney. That's the difference, right? That the idea of I don't have much by way of money, I don't have kids, because again, the threshold for wills, in my opinion, is do you have children? Because if you have children, you need to determine guardianship. Right. So if you have someone who doesn't have children, again, if they're not as concerned with where their money goes, fine. If they're not concerned with sticking someone with probate, okay. But they ought to have those powers of attorney in place because they're one moment away from incapacity. Sure. And making sure we have people nominated to make those medical and financial decisions, regardless of asset level, regardless of whether you have children, is an important thing.
When it comes to being an executor, somebody has, maybe worked with you, maybe a couple has worked with you to build a will and a trust. Everything's good to go, and they both pass away, and now it's time for an executor to step in. Walk us through a little bit about, maybe the executor hasn't worked with you. How does that process work?
Yeah, so the first step it really depends upon is, did the people who deceased in this scenario, did they create a will or a trust? Because it kind of leads you down two separate paths. But either way, what I will do, just like I offer free initial consultations for clients, I also offer free initial consultations for executors or trustees. And I kind of walk them through what the plan is, figure out a little bit about what they're doing, what their parents had, and come up with a plan. And then, like I said, for my clients who create trusts and for my clients who follow my directions, that's the other thing too, right? And I say that with all due humility. I mean, it's the cliche, you can lead the horse to water, but you can't force it to drink, right? I give my clients thorough written and verbal instructions, but I'm not holding their hand walking into every bank and financial institution to say they follow them. So assuming they follow my advice, it's almost on a silver platter what the trustee needs to do. So for those clients, 95% of the time I meet the trustee once and I never hear from them again. I don't charge them a dime. But it's important that they follow those instructions. If they don't follow those instructions, then we may inadvertently trigger probate. We may have other issues that come into play. So,
all right, very good. Again, visiting with Rob Melick with Melick Law, with all your estate planning needs, wills, trusts, powers of attorney, whether they be health or financial. And as you heard today, a lot of things to think about when it comes to these things. They're not always quite so straightforward as you might think. So if you've got questions, certainly give Rob a call. And Rob, if you would throw your information back out there for folks who want to get in touch with you.
Absolutely. Best way to get in touch with me, any of my offices, call or text 262-347-3444. Again, 262-347-3444. Offices in Beaver Dam, Saukville, West Bend, Germantown. Free initial consultation, 20% discount for WBEV listeners and dailydodge.com viewers.
And folks can find you at your website too, and actually your website addresses some of these things we talked about today.
It does. So the website is melicklawwi.com. So M as in Mary, ELICK, law, LAWWI.com. I would have had melicklaw.com, but there was another attorney, Melick, out in Rhode Island who beat me to it. So
pesky.
Yeah, I had to add the WI at the end for Wisconsin, obviously. So that's the website, melicklawwi.com.
All right. That is attorney Rob Melick with Melick Law. Rob, always great to have you in. Thanks for all the great insight that you provide for us.
Thanks for hosting today.
And the preceding program was a paid presentation of Melick Law. The views and opinions expressed are not necessarily those of Good Karma Brands, its management, or its employees.